Thanks, Duncan. So, share out. See that? Come up for everyone.
Yep, got that.
Yep.
Okay, so this is information governance in data analytics with me, Tom MacGregor. That's me there. I'm a senior information governance officer at Essex County Council, and I work exclusively for our data and analytics team. I've been at ECC and work in IG for just over 5 years now, and I've been in this role since January. So what we're going to cover today, we'll go through what data protection is, what personal information constitutes, which may be a bit like sucking eggs for some of you if you've done it before, but we'll just cover the basics. When might we need to do a DPIA and any considerations when doing this? My IG colleague Will Jilks will then give you a break from my voice to talk about international data transfers, so any data we're sharing that might be leaving the UK. I'll come back and talk a bit more about when you should engage with IG. I'll talk about information sharing protocols. You may also know these as information or data sharing agreements, but essentially a document to record how you will share data with a partner outside of any contracts. And then Katie Bennett, one of our senior data analysts at ECC, will talk a little bit about her experiences working with IG as part of a recent project before finally I'll go into a bit of detail about what the ICO Data Analytics Toolkit is and how it might benefit you. And then we'll allow some time for questions or anything else you'd like to discuss at the end of the session. There's also a mild bit of interaction expected as well. Mostly it's early on, so please do try to get involved where you can. So to start, what is data protection? So data protection should form part of your everyday work. It isn't something that you're expected to do extra. The main purpose of data protection is to protect individuals from having their personal details misused or mishandled. And by protecting the data, we protect the individual. So this reduces risks and we can use it to build and sustain people's trust. It's not about preventing processing, it's about making sure that we're doing it in the right way. So data protection doesn't just impact your work. With data being processed more than ever, it's become a part of our day-to-day lives. You would have all come across something relevant to data protection already today, such as cookies or pixels on websites, sharing information on your social media, or logging into your laptops. So the current data protection legislation includes Data Protection Act 2018, Dpia, and the UK General Data Protection Regulations, or GDPR. So almost anything you do with data counts as processing. So this is collecting, recording, storing, using, analysing, combining, sharing, deleting it, anything. And so to kick things off, here's a bit of that mild interaction using either the meeting chat or coming off mute to say it out loud. What's the first thing that comes to mind when you hear the words data protection? Sort of a bit of a word association. I did do this in social care training once and somebody actually said boring, but they did change their opinion by the end of the session, or at least that's what they told me to my face. So yeah, using the meeting chat, coming off mute, what is the first thing that comes to mind when you hear the words data protection? Anybody at all?
We've got a lot in the chat already, Tom. GDPR, safety, fines, privacy, legal, trust, some more GDPR, security, regulations, responsibilities.
IPP, identify personal information.
Yeah, loads of good examples there, so we're well across that. So then moving on, who does data protection apply to? So who would have rights under data protection? So again, using the meeting chat coming off mute, we've got 4 options there. And as a hint, there's only one correct answer. So A is Alan Rickman, B is Amazon, C is Bart Simpson, and D is our chief exec at Essex County Council, Gavin Jones. So data protection only applies to one of these, or only one of these people has rights under data protection. Which one do we think it is?
Yeah, the consensus in the chat is D.
Most people going with D, and that is correct. So data protection legislation applies only to living individuals. So Alan Rickman is sadly no longer with us, but we would still need to be mindful of our duty of confidentiality to the deceased. So for B, Amazon, they're a company or an organisation like ECC. They need to comply with the legislation, but they don't have any rights under it. And obviously Bart Simpson is a fictional character, and so he wouldn't have any rights under data protection legislation. So then following on from data protection, what is personal information? So personal data is anything that can be used to identify someone. You don't just need a name to identify someone. Again, using the meeting chat, what sort of things do you think constitutes personal data?
Date of birth, address, gender, ethnicity, school, home address, health conditions, yeah, names.
Again, lots of good examples. There's a few more there in the picture on the slide. So if you think about a neighbour who lives down your road, you may not know their name, but you might be able to describe them to somebody else on your street. They would probably know who you were talking about. That person may even have a better relationship with them and be able to tell you their name and other details about them. Now, all of a sudden, you've combined your data with somebody else's about the individual and they're fully identifiable. We require a lawful basis to be able to process people's personal information. So, for example, a public task in the public interest. So the processing is necessary for us to perform a task in the public interest or in our official functions, and the task or function has a clear basis in law. Now, if we want to use certain more sensitive information, special category data, so this is information that could be used to unlawfully discriminate against an individual and is especially sensitive, and therefore we require that additional lawful basis to process the information. So, for example, health or social care is one of these lawful bases. And so ECC, for example, as a public authority, have to provide social care as part of the Care Act. Special category information is that bit more sensitive, and it includes things like racial or ethnic origin, political opinions, religious or philosophical beliefs, biometric data, genetic data, any information concerning a person's health, their sex life, or their sexual orientation. So that's information that can be used to discriminate against somebody unlawfully. So now we've sort of gone through the basics. What is a DPIA and when do we need to do one? So unfortunately now that is pretty much the end of the interaction. You're going to have to just listen to me talking now for a while. So what is a DPIA? So does anybody know what DPIA stands for?
Data Protection Impact Assessment.
It is, thank you, Lily. So a DPIA is a process designed to help you systematically analyse, identify and minimise data protection risks of a project or plan. We have to do these under UK GDPR, and when done properly, they help you assess and demonstrate how you comply with all of your data protection obligations. The objective isn't to remove all risk, but it should help us to minimise it and determine whether or not the level of risk is acceptable under the circumstances, taking into account what we're looking to achieve. So conducting a DPIA does not have to be complex or time consuming in every case, but it should be proportionate to the risks involved. This takes us on to why they are important. So as I said a moment ago, we'd have to do DPIAs. It's a legal requirement for any type of processing, including certain specified types of processing that are likely to result in high risk to the rights and freedoms of individuals. Now, under UK GDPR, failure to carry out DPIA when required may leave us open to enforcement action. including a fine of up to £8.7 million or 2% of global annual turnover. So as public bodies, it's highly unlikely we'd see fines that high, especially given the current climate. But that's not to say we can be slack on these sorts of things. I think this is okay, it's only going to be a small fine. They will fine and have fined local authorities and public bodies, and they will hold us accountable. There is also the considerable reputational damage that can come from this, and individuals can be fined and held accountable as well. Not to mention any fine is taking money away from the public purse, which we could be better spent on the people we should be serving. So by considering the risks related to your intended processing before you begin, you also support our compliance with another obligation under the UK GDPR, which is data protection by design and default. So the use of DPIAs increase the awareness of privacy and data protection issues within the organisation. It also ensures that all relevant staff involved in designing projects think about privacy at the early stages and adopt a data protection by design approach. However, DPIAs are not just a tick box exercise. An effective DPIA allows us to identify and fix problems at an early stage, bringing broader benefits for both the public and the organisation. These can also help reassure the public that you're protecting their interests and have attempted to reduce any negative impact on them. There can also be financial benefits. So by identifying a problem early, it generally means a simpler and less costly solution. And a DPIA can also reduce the ongoing costs of a project by minimising the amount of information you collect where possible and devising more straightforward processes for staff. So how are DPIAs used? So a DPIA can cover one processing operation or a group of them if they're similar. Also, if you're doing a collaborative piece of work with other organisations, a group of controllers can also do a joint DPIA for a group project. For new projects, DPIAs are a vital part of data protection by design. They build in data protection compliance at an early stage when there is most scope for influencing how the proposal is developed and implemented. A DPIA shouldn't be seen as a tick box exercise, as I mentioned before. It's important to integrate the outcomes of the DPIA back into your project plan. So they also need to be kept under review and reassessed if anything changes. For example, if you make changes to an existing system, in particular, if you make any significant changes to how or why you process personal data, or to the amount of data you collect, or if a new security flaw is identified, if new technology comes into the equation, or a new concern is raised by a member of the public. So what kind of risks do DPIAs assess? There is no explicit definition of risk in the UK GDPR, and there are several things they don't define but provide guidance around, but essentially this is about the risks to individuals' interests. The legislation says that DPIA must consider risks to the rights and freedoms of natural persons, so people like Gavin, as we went through earlier. This includes risks to privacy and data protection rights, but also effects on other fundamental rights and interests, such as where the processing may give rise to discrimination, identity theft or fraud, financial loss, damage to reputation, loss of confidentiality that should be protected, unauthorized reversal or pseudonymization, which can certainly be a big thing in data analytics, or any other significant economic or social disadvantage where data subjects might be deprived of their rights and freedoms or prevented from exercising control over their personal data. So the final bit of this part, when do we need to do a DPIA? The UK GDPR says that you must do a DPIA where a type of processing is likely to result in a high risk to the rights and freedoms of individuals. High risk, though, can be subjective. However, there are 3 types of processing that automatically require a DPIA, and the Information Commissioner's Office, or the ICO, has published a list setting out 10 more. This does not mean that these types of processing are always high risk or are always likely to cause harm, just there's more chance that this may be a case of happening, and so we do a DPIA to assess the risk level in more detail. So the 3 set out by GDPR are systematic and extensive profiling with significant effects, large-scale use of sensitive data, so that's a special category data we mentioned earlier, and public monitoring. Public monitoring includes automated decision-making with legal or similar significant effects, systematic monitoring, sensitive data or data of a highly personal nature, data processed on a large scale, matching or combining data sets, data concerning vulnerable data subjects, innovative use or applying new technological or organizational solutions, preventing data subjects from exercising a right of using a service or contract. So again, you can see already how some of these relate to sharing data and data analytics. You may be able to justify a decision not to carry out a DPIA if you're confident that the processing is unlikely to result in a higher risk issue, but you need to document your reasons for not doing one. However, I think it's always good practice to do that risk assessment, and it may throw up something you hadn't thought of previously. So further to those 3 reasons in the UK GDPR, there are 10 reasons from the ICO, and these include innovative technology, any use of that, so any artificial intelligence, intelligent transport systems, market research involving brain activity, a denial of service, large-scale profiling, any use of biometrics, any use of genetic data, data matching, so combining, comparing or matching personal data obtained from multiple sources. So again, that's likely to figure highly in the work that we're doing. And invisible processing of personal data. So this is information that hasn't been obtained direct from the data subject. Tracking, so processing which involves tracking an individual's location or behaviour, targeting of children or other vulnerable individuals, or the risk of physical harm. So we now know what DPIA is and when we need to do one, but what do we need to consider when completing one? We need to be able to describe how and why we plan to use the personal data. This description should include the nature, scope, context, and the purposes of the processing. So things that come under the nature of processing is what you plan to do with the personal data. So how you collect the data, how you store it, how you use it, who has access to it, who you're sharing it with, are there any processes involved, how long are we keeping the information for, any security measures, and whether we're using any new technologies or novel types of processing. The scope of processing is what the processing covers and should include the nature of the personal data, the volume and variety of it, the sensitivity of it, how often we're going to be sharing the information, how long for, the number of individuals involved, and the geographical area covered. Context of the processing is the wider picture, so you might include the source of data, the nature of your relationship with individuals, how far individuals have control over their data, how much they're likely to expect the processing, whether they're children or vulnerable people. Have we done this sort of processing before? Any relevant advances in technology or security? Any current issues of public concern? And our compliance with the codes of conduct in the GDPR, and whether we've considered complied with any relevant codes of practice. And the purpose of the processing is a reason why you want to process the personal data. So this should include your legitimate interest where relevant, the intended outcome that we've got for individuals from doing this, and the expected benefits for either the organisation or for the public as a whole. You also need to take into account and consult all relevant internal stakeholders, in particular anybody with responsibility for information security, so anybody in IT or IT wizards. Other things we should bear in mind include, are there any other reasonable ways that we can achieve the same result without processing this information? Are we sure in the data protection compliance? Do we have a lawful basis for the processing? How are we ensuring data quality and data minimization, so only using what we need? How are we providing privacy information? So typically this would be links to our privacy notices. How are we implementing individual rights? So how are they going to access it? Can they ask for their information not to be used? What safeguards do we have for international data transfers, which my colleague will go into more depth shortly? Have we identified and assessed the risks, and have we managed to mitigate these risks? And if so, how have we done it? Now, you don't necessarily have to eliminate every risk. You may decide that some risks, even a high risk, are acceptable, given the benefits of the processing and the difficulties of the mitigation. So there's sort of weighing up either side there. However, if there is still a high risk, you'll need to consult with your data protection officer. If you have decided to accept a high risk, either because it's not possible to mitigate or because the costs are too high, you then might want to consult the ICO before you go ahead with the processing. To aid transparency and accountability, it is a good practice to publish your DPIAs. However, here at EECC, we don't do this currently. We have released DPIAs in the past, though, as part of Freedom of Information requests, and publishing them is something we may look to do so in the future, but at the moment there is no requirement to do so. I fully appreciate that the last couple of slides is a lot to remember and has involved me just talking at you, really. I'm sure we'll be able to get the slides sent out, and also I can provide some useful links as well if you want to know a bit more about this. I'm now going to hand over to my colleague Will Gilks to talk you through international data transfers, so when we are processing information outside of the UK.
Thanks, Tom. Hi, everyone. Hope you're doing okay. So the ICO likes forms, and they've created a couple more for us to fill in with international data transfers. What is an international data transfer? On February 22nd this year, the UK government laid out the International Data Transfer Agreement, IDTA, and the International Data Transfer Addendum, also IDTA, to be confused and also not to be confused. This is a replacement for the standard contractual clauses, SCCs, for international data transfers. This is for the protection of transferring personal data outside the UK from the UK GDPR to the EU GDPR due to Brexit, as well as the UK to other countries outside the EEA. Lots of acronyms in this. If you don't know what they are or want me to go over, please just say or let us know in the comments. So standard contractual clauses, SCCs, are still in use and can be used until the 27th of December this year, and they can be in force until September next year, at which point all SCCs become nullified and all contracts should include IDTAs. So what's the difference between the SCCs and the IDTA agreement and addendums? So the IDTA is a single checklist type document. The SCCs are separate documents based on the nature of the role of the parties involved. For example, controller to controller, controller processor, etc. And they all need to be included and verified within the contract. Significantly, the IDTAs can cover transfers to organisations located in third countries outside the EEA, whereas these used to need to be set out within the contract as well. For those that are within the EEA and currently use EU GDPR, you need to complete the IDTA addendum, the shorter version. This covers the small differences between the UK and EU GDPR. For transfers outside the EEA, the International Data Transfer Agreement, that's the other one, and that's the longer version, needs to be completed. So who completes IDTAs? Essentially, and very simply, whoever is sending the data outside the UK needs to complete these. For controller to processor, the IDTA needs to be completed alongside the DPIA. Basically, all the information in the DPIA should allow you to complete the IDTA quite easy. If you're using a third party who sends the data abroad, I've got one of these currently. So for an example, we are using a system, we send the data to them all inside the UK. They have got a development centre based in India. They are sending that information to India. It's then a processor to sub-processor transfer, and they need to complete the IDTA. They also need to give us a copy of that, so we can include it in the contract, so everything's all watertight. So we don't always have to complete the IDTA depending on the process. The transfer even relates to companies that have headquarters in the UK, but also all around the world. So if the data is collected in the UK and transferred to another country, even if it's in the same country, in the same company, an IDTA needs to have been completed for this. So it doesn't matter if it's the same company, it's where the data is going to be looked at, stored and sent to. Unfortunately, there is no ICO guidance on how to complete an IDTA at all. It's using your best judgment at the moment. Some questions are very easily misinterpreted or difficult to know exactly what is required. The ICO have said that they will give guidance out by September. We're still waiting for news if that's for definite. As I said, the easiest thing for international data transfers is to complete the DPIA. That information will be easily transferred. It'll make it a lot easier and quicker. That's a basic overview of IDTAs, and hopefully that's some help. But any questions, you can catch us later. Tom.
So that sort of highlights as well why we prefer to use companies within the UK, but obviously that's not all possible in the future. I've said lots of acronyms, so if there are questions, we can pick up on them at the end. So when should you look to engage with IG? I mentioned it several times already, but simply as early in the process as possible. The earlier we're made aware, the easier it will be to find mitigations to any risks there might be and look at ways we can remove any barriers or blockers. There's nothing worse, at least for me, than getting a message asking for help once software has already been procured or new contracts are ready to be signed, and there is an expectation then placed upon you to work around what we have rather than building it together. So we've engaged IG, completed the DPIA about the activity we're undertaking, but this also involves sharing information with another organisation. Do we need an ISP? So information sharing protocols set out the purpose of the data sharing. They cover what happens to the data at each stage. They set standards and help all the parties involved in sharing to be clear about their roles and responsibilities. Having a data sharing agreement in place helps you to demonstrate you're meeting your accountability obligations under the UK GDPR as well. These are not compulsory, however, and your organisation might use a different title, or you may know these as a different name. So other things you might have heard them called as an information sharing agreement, a data sharing agreement, a data sharing protocol or contract, or a personal information sharing agreement. Whatever you know it as, it's good practice to have a data sharing agreement in place when sharing data with other organisations. Now, government departments and certain other public bodies may enter into a memorandum of understanding with each other instead, which includes data sharing provisions and serves the same purpose as an ISP. However, on their own, do not necessarily constitute a data sharing agreement. What are the benefits of having an ISP? So by putting this into writing, they help all the parties involved be clear about what their roles are in the sharing. They set out the purpose of the data sharing. They cover what happens to the data at each stage, and they set the standards. It should help you to justify your data sharing and demonstrate that you have been mindful of the relevant compliance issues. There's no set format for an ISP. It can take a variety of forms. Some of you may have seen the template that we've created here as part of the wider Eastern Information Sharing Framework in YSF. Since an ISP is a set of common rules that binds all the organisations involved, it should be drafted in clear, concise language that is easy to understand, especially as those responsible for signing it off may not be familiar with the work you're doing. And as a bonus, even though it's not mandatory to be completed, the ICO will give you points for the existence of any relevant data sharing agreement should they receive a complaint about the sharing. So what do we need to include in these agreements? We need to include who's involved, who are the controllers and who are the processors of the information, what the purpose of the data sharing is, so the aims you have, why the data sharing is necessary, and the benefits of the sharing to the population, what items we're going to be sharing, so your agreement should set out the types of data you're intending to share, and who within the organisations will have access. What is our lawful basis for sharing? So as we mentioned earlier, you need to clearly explain your lawful basis for sharing the data, and the lawful basis for one organisation in the agreement might not be the same as that for anybody else. We need to consider if there is any special category data, so that information that is extra sensitive. And again, we need to explain and document that additional lawful basis we'd be relying on for sharing this. Have we implemented access and individual rights? So we need to set out procedures for compliance with individual rights. So this includes somebody's right of access to information as well as their right to object, and how to make requests for rectification and erasure. We need to make it clear in the agreement that all controllers remain responsible for compliance, even if you've set out processes on who should carry out which tasks. So in addition to these, we also need to ensure we have common rules for the retention and deletion of the shared data items, arrangements for the transmission and the sharing of data, and procedures for dealing with any breach of the agreement in a timely manner. So what is a notification process? have procedures for dealing with the termination of the data sharing initiative. So when it finishes, how we're going to delete it, or how we're going to return the information to the organisation that supplied it originally. And if this is an ongoing agreement, when we're going to look at reviewing it. So I will now hand you over, hopefully, to Katie, who will take you through her experiences of working with IG.
Hi everyone. Thanks for having me, Tom, as part of this ECTA session. So I think there's introduction at the start, but hello, I am Katie. I'm a senior analyst working within the data analytics team here at ECC, and I've been involved in the IG process of a project really recently. So this project was a collaborative one between ourselves and Mid and South Essex Hospital Trust. This project is all about investigating inequalities in waiting lists for treatment at Mid and South hospitals. So part of this was kind of combining our own social care data with the trust data to kind of get a better idea of what's going on with the people who are waiting for treatment. So the first couple of meetings I attended for the IG of this project were crazy. We had people from ECC, Mid and South, and IBM who were also involved, and they were kind of talking tongues to me. So, you know, DPIA this, ISP that, and I had absolutely no idea what was going on or what was being said. Everyone seemed to be going at about 1,000 miles per hour. So I really had to take the time to fully understand what each element of the IG process meant for me and why it was so important. But the thing is with IG, it's like going to France and being surrounded 24/7 with people who only speak French to you. You're going to pick it up a lot quicker because you're constantly surrounded by it all the time, and you never get a break from it. So the best thing to do at this stage was to try and be as involved as possible with all areas of IG. So our project was one that did need an ISP, and that was a shared job between us, ECC, and Mid and South. In addition to this, our project is also being used as a kind of proof of technology project, which basically meant we were testing out 2 data sharing platforms, which were, one was Snowflake and one was Azure. And obviously any new method of sharing our data does need to go through the IG process. Luckily for us, ECC is migrating to Azure anyway, so we as an organisation had a lot of documentation already available to us on the Azure side. However, Snowflake was a bit of a challenge as we needed a DPIA to come from the organisation who were procuring Snowflake themselves, so that would be Mid and South. So from my experience working through the IG process with external organisations, I now really see the importance in why it's there. It provides a roadmap for best practice and enables us to share data with full confidence as it lowers the risk of things going wrong. However, one thing I would say is that best practice for IG can sometimes be seemingly subjective, and sometimes other people you're working with might not see eye to eye with the rather rigid nature of the IG process. And what I mean by this is that sometimes other priority tasks within the project might cloud the importance of IG, like nearing deadlines and different views on the overall aims of the project involved. However, I think it's really important to realise that without correct IG in place, this project would simply not exist for us. The hardest thing to achieve, in my opinion, is making everyone in the project that's involved in the project kind of realise this. For me, I was lucky to be part of a team who really support best practice in IG, and I've learned a lot from them all because of this. However, I do think it's everyone's responsibility to upskill themselves in this area when they do join a project like the one that I'm currently assigned to at the moment. Finally, I cannot stress the importance of using your IG lead as much as possible. Not only will they want to know what's going on anyway within projects like this, but they will be able to guide you through the process to make sure that you don't miss anything out. I was actually given the opportunity to co-author the ISP and DPIA we produced for the project, but my IG lead was Tom, and his guidance was crucial to making sure that I'd covered everything that needed to be covered within that documentation. In times when there was difficult scenarios presented to us, Tom was able to step in and either give advice on how to solve them ourselves as a team, or he could step in and lead particularly complex conversations. Your IG lead is there to give support, and certainly in my experience, no question was too stupid in Tom's eyes. So don't worry if you've literally never heard of an ISP or a DPIA before, because that was literally me at the start of this project. Just use your IG lead as much as possible for support and guidance, and you do pick it up quite quickly. So thanks.
Thank you, Katie. Transfer that money. So the last section now then is the ICO Data Analytics Toolkit. There she is analysing all that data on the screen. The ICO defined data analytics as the use of software to automatically discover patterns in data sets where those data sets contain personal data and use them to make predictions, classifications or risk scores. And a really useful tool they provide is the Data Analytics Toolkit, which you can also be used to ensure you've taken all the relevant considerations into account. The toolkit takes you through step by step and follows two pathways depending on the legal framework for processing, whether it's general processing under the GDPR or the Data Protection Act, or if it's for law enforcement processing. So the likelihood is that we will be using general processing. So if you choose that option, it will ask you questions such as, have you completed the DPIA? Have you identified any risks? Have you implemented the data protection principles and considered individual rights? Are there any competing interests, as Katie mentioned, such as deadlines or what you're looking to get out of the project? Have you worked out the lawful basis for sharing? Is there any special category data involved? Is there any automatic decision making involved? Is your use of data and analytics fair? How are you monitoring for bias and discrimination? Does your privacy notices cover what you're doing, or do you need to look at amending these? What security measures are involved? And finally, is what you're doing, does it meet those 3 points that we always come back to in IG, which is it adequate, relevant and limited to what is necessary? So once you've answered all the questions, and they are only tick boxes on the ICO website, you'll be provided with a report of any next steps you need to take, so anything you've missed or what to look out for next. If you are doing it as part of the law enforcement processing, they will ask similar questions, but with a deeper focus on accountability and compliance with the data protection principles. And a lot of this information is what you should be capturing in your DPIA anyway. So by using this and taking advice from your local IG team, you'll be in a really strong position to share your data lawfully. And I will put a link to the toolkit in the chat if that is any help to anybody. So that brings us to the end of the session. I hope it's been helpful and given you some ideas about what you might need to consider going forwards. Of course, your IG professionals will be available to advise and guide you through these processes, but I think having this extra understanding will ensure you're able to answer some of the questions that they might have for you before they need to ask them, and ultimately should result in a more efficient process for all involved. I recognise that is the Riddler, not the questioner, but he's covered in question marks. So if anybody does have any questions or anything else they'd like to share, now is the time.
Great, thanks, Tom. I'll just wait to see sort of hands to go up, or just call out or bring yourself off put your camera on. I think Nikki wants to go first.
Cool, thank you, Tom. Apologies, I won't put my camera on because I'm in an awkward position at the moment, but I think it's really helpful in terms of what you've kind of covered there. And I guess kind of I wondered if you had any guidance that you would send out, because I know you've covered a lot of kind of information that kind of is not necessarily on the slides, but it'd be really helpful to kind of share some of that, because I think there's some really good principles in there that we should be sharing around as analysts to other people. And I think it just highlights how this is an enabler to do our work and to do it well, kind of ethically and kind of legally, and we should be working with people to overcome some of those barriers in the right way. So I guess kind of it's just really helpful, and thank you for the kind of presentation that you've done here, and hopefully we can kind of think about kind of how it is an enabler rather than a barrier, and that will kind of help us to work with partners on that, having kind of similar understandings of the kind of terminologies that you talked about there at the beginning.
We must have resources internally, at least, that I can send out, and certainly for people externally, I can put a list of sort of links together that people might find handy, can go out with the slides.
I think that'd be great. Thanks, Tom. I think, yeah, I was thinking that. So the slides are great, but some of the sort of, say your notes, the things you're talking about, would be really helpful to share, as you say, and links to the toolkit. Got another question in the chat from Vicky, who's saying, how could she find out if there's a DPIA and or ISP in place already, if sort of, she's been asked to engage with a project or, start to work in terms of reporting data? Is there a way she can find out if an ISP is already in place?
I think certainly with us, they're not searchable because we don't publish them, or certainly not the DPIAs. The quickest thing to do is probably go to your IG lead. We've got, certainly in ECC, we've got a spreadsheet, so we know everything that we've done in the past, and hopefully there'll be similar sort of records across sort of the public sector and the partners that are also involved in ECTA.
Thanks, Tom. Just while I'm waiting for another one, just a quick one for me. So it's interesting to say that you can do joint DPIAs for sort of those partnership projects. Obviously, ECTA very much in that space of doing those sort of partnership projects. But my question, I guess, is about, you mentioned there might be different legal bases for different organisations. So does that can still go within one ISP, but explaining what the different legal bases are, is that correct? There can still be one ISP?
Yeah, I think as long as we're sort of highlighting and documenting exactly what applies to who, then there's no reason why it can't all be within the same document.
Yeah, and Vicky's just asking for a list of sort of to contacts, if you like. So I think it's going to be different, obviously, for each organisation. But obviously, as Vicky's ECC, yeah, we can get that for you, Vicky, no problem. Are there any other questions for Tom, Will, or Katie? Yeah, Tom, can you see Liz's comment in the chat? About what sort of, I think it's about sort of, there is what types of information can be shared without these agreements in place.
So the information sharing agreements are usually for, so internally, you don't need one internally, and they're usually for sharing information where there's not a contract in place. So you might have a provider where it's already covered in the contract that you'll be sharing information, or they'll be collecting certain information that you have access to. So I think it's worth remembering these agreements are typically for when we're sharing outside of the organisation to people that we might not have shared with before, or that we don't have any sort of legal basis or contractual arrangements in place with. And so we need that. As I said, they're not mandatory, but they just help to sort of document the processes that we're going through for sharing that information. Hopefully that answers your question.
Yeah. Just a sort of final one for me, Tom, as well. So you mentioned there was no set format for an ISP, but you mentioned that there are sort of some templates available for sort of the YSF framework. Are people able to access those somewhere? Are they available for people to sort of find?
I think that has now been taken down, but
so maybe we could put through us, if people wanted to sort of see that, they can come through sort of the ECTA inbox, or ask me if you like, and we can show them what that looks like.
Yeah, and it may be something we'll want to look at for going forward, sort of branding our own sort of ECTA one.
Yeah,
that people can use.
Okay. What a question there from Nigel. I don't know if you can see that in the chat, Tom.
What happens if you're working with multiple researchers or you're using freelancers? I guess it's sort of trying to get as many people around the table to have these conversations as possible. Certainly with things like freelancers, I imagine they're not going to have IG personnel or DPO leads or anyone sort of. So I think it's about trying to be as fair as possible, making sure that we're giving them the right information At the end of the day, when as IG professionals, we're doing it to support the public rather than the organisation. We need to have the individuals at the forefront of what we're doing. So I think as long as we're doing that, there's no reason why we can't sort of lead these conversations on behalf of freelancers or multiple researchers that might not necessarily have access to their own IG teams. We're really fortunate at ECC. We've got quite a large team, and I know that's not the case everywhere.
Thank you, Tom. I've got a question from Tom. Other Tom.
Yeah, it's sort of a comment, not so much a question, but I guess it's for everyone other than Tom, actually, because I think we've been through quite a lot of these projects in the last few years where we've been sharing information and we've been using information, sharing protocols and things like that. And I think it's really important that we don't see it as something that's palmed off to an expert. Like we're really lucky that we've got Tom, who works really closely with us, but it's really important that analysts and people involved in the projects have an understanding of what's going on and what they are able to share and why. And there's several reasons for this, but one of them is because for every big project that we've done, we have had to go and get it signed off by the Caldecott Guardian or the data owner, which in most cases has been an exec director. And they will ask, why are we doing this project? What is the benefit of doing this project? And it's important that we're able to answer that question. And yeah, I guess it's really helpful for us to have someone who is so knowledgeable about IG, who is on hand to answer our questions. But it is really important that we don't just think it's Tom's job. It needs to become part of everyone's job, you know. So yeah, I just wanted to add that, but thank you, Tom.
Yeah, I think it's good that we get to a stage, not just in ECC, but across the public sector, where we see more as and guidance. The doer, we can provide the expert knowledge, but a lot of the initial work needs to come from people involved, I think.
Well said, both Toms there. Yeah, Tom Waldworth, that's a really good point, that it's sort of everyone's business and the benefits of the analyst person working on a project, understanding it. Yeah, really important. We're just coming up to sort of close, so if there's no further hands, I just wanted to sort of close by sort of thanking Tom, Will and Katie for their input. Really, you know, so I wanted to do a session for a while, so thank you very much for that. We will send the recording round along with the slides and any sort of notes or links that Tom wants to sort of share, particularly that sort of ICO toolkit, I mean, particularly useful, but any others as well we will send round. I think the only other thing I want to say is that I think we're going to give you August off, so we're not going to have an event in August, but in September, look out for one. We're going to do a particular session with some sort of national renowned experts around data ethics. So I think that will be really interesting. So look out for that. And as always, if there's topics or piece of work that you particularly would like to share or hear about from another organisation that you picked up on, please let me know, or the ECTA inbox where these invites come from, and we can pick up and put it on our forward plan. So if that is all the questions, thanks everyone for attending, and see you all soon. Well, we'll do, Vicky.